Hello and welcome to this webinar presented by the Pennsylvania MGMA in collaboration with Connecticut, Delaware, Maryland, Massachusetts, Rhode Island, New York, and Virginia MGMA. My name is Julia Linko and I will be your host. Today's presentation is led by Daniel Shea. Daniel Shea is an attorney with Alice G. Gosfield and Associates, PC. His practice is restricted to health law and health care regulation, focusing primarily on physician representation, fraud and abuse compliance, Medicare Part B reimbursement, and HIPAA compliance in the physician context. He's also interested in intellectual property issues, including copyright, trademark, data control, and confidentiality. He has also focused his attention on providing control of commerce and data, electronic health record license agreement, physician advertising, enrollment in Medicare, quality reporting, and quality measurement, physician use of non-physician practitioners, and physician use of social media. Mr. Shea received his Bachelor of Science cum laude in 2000 from Vanderbilt University and his Juris Doctorate degree from Emory University School of Law in 2003. Mr. Shea is admitted to the Pennsylvania Bar, is a member of the American Health Lawyers Association, and is the Vice Chair of Education and Programs in the American Health Lawyers Association Physician Organization Practice Group. Before we get started, I would like to review a few housekeeping items and let you know how you can participate in today's web event. The viewer window is on the right and allows you to see everything the presenter is sharing. The control panel is on the left, and this is how you can participate in the webinar. The audio panel provides audio information. By default, you have joined the webinar using microphone and speakers. If you prefer, you can join the audio using your telephone by selecting Use Telephone under the audio drop-down box. The dial-in information will be displayed, including the audio pin. During the presentation, you have the ability to send the questions to our staff through the chat box found on the left side of your screen. Simply type in your questions and click Send. At the end of the presentation, we will do a question and answer session. As a final reminder, we are recording today's webinar. You can view a copy of this presentation and the recording on a participating MGMA website. Please welcome Daniel Shea with Legal Risk and Social Media.
Well, thank you very much, everybody, and good afternoon. We're going to be discussing legal considerations in social media today. This is just some contact information from me, and by the way, if MGMA hasn't provided you with a copy of the slide deck, I will be happy to circulate it to anyone who asks. So let's start off with just a brief discussion here about social media in general. Usage of social media is basically a fact of life now. Most people have social media accounts in one platform or another. Since 2005, U.S. social media usage has increased from 8% up to 77% of American adults by 2016. Social media can be attractive to healthcare providers who see it as a useful marketing tool. They may also view it as an effective way to communicate with patients just generally. Patients are absolutely interested in using social media. They probably already have an account that they use just for their own personal use. It is possible that use of social media could help improve quality of care as well, but it's important to understand the risks involved in the use of social media for physicians and physician practices. I'm also, just before I get into the overview here, I primarily represent physicians and allied health providers, so while I think that the information that we're going to cover today is useful to a wide range of providers, that's sort of my bias, my frame of reference in terms of how I tend to look at these issues. So just a quick overview of the presentation today. We're going to start by giving a general discussion of social media. Then we're going to discuss legal concerns focusing on HIPAA and confidentiality and also on medical malpractice risks. And then we're going to discuss some practical guidance for physician practices. Before I get into reading the definition here or discussing the definition, I want to provide a little bit of background on why we're going to be discussing social media in general. I apologize if any of this is basic to people. I have no idea what everybody's level of expertise is with social media or their familiarity with the various platforms out there and their intricacies, but I think that having a good understanding of how these platforms operate can be really useful in managing your own compliance efforts with respect to social media. It helps if you know how social media tends to be used and what it's capable of so that you can effectively design policies and procedures to address usage surrounding the workplace. So we have here a definition of social media from Merriam-Webster.com, which reads as forms of electronic communication such as websites for social networking and microblogging through which users create online communities to share information, ideas, personal messages, and other content such as videos. It's a bit sterile as a definition. I think it's more helpful to discuss what are some of the common features of social media. Social media generally allows you to post a wide variety of content. This can be text, images, videos, links to other pages, and sometimes they'll include a little preview of what you're going to see on the page that you're going to link to, links to other social media accounts, so you can post a Twitter post on someone's Facebook page and vice versa. And also the ability to embed content, which means that you make the content visible directly on the social media platform. That's different from linking to it. So to sort of explain the difference for folks who don't understand or who are unfamiliar with this, imagine that you post a link to a YouTube website video. You would then click on the link and it would take you to YouTube where you would view the video. Embedded content would mean that you could embed the video itself on the social media platform so that you could play it without being taken to YouTube's website. It would play, say, on Facebook in someone's Facebook feed. Obviously, social media also allows you to connect to other individuals. Usually you can also connect to friends of your friends or connections. You can make connections with people to whom you're already connected and their connections, basically leading to a sort of 6 degrees of separation scenario, or from my perspective, because I'm based out of Philadelphia and he was born here, 6 degrees of Kevin Bacon. You can also typically you can send messages to other individual users. In some cases you can send messages to groups of users and use like a chat window basically. So let's talk about what are arguably the two most popular social media websites. We're going to start with Facebook first. Facebook estimates that it has 1 billion with a B active users per month. It has most of the common features that I've already described, and it allows you to create what are known as profiles and also pages. A profile is an individual user's Facebook account, essentially. A page would be an account that could be used for a business, for a social group. You can use it for fan groups. You can use it for any number of different things, but the clear distinction there is that profiles are for individuals and pages are not. So, the Rolling Stones don't have a profile, they have a page. Pages can be managed by administrators, which can give you the ability to do things like track how many people have logged in the month, how active various users of the page have been, what have been the most popular postings on it. Profiles don't really let you do that, or at least I'm unaware of the ability to do that if they allow you to. Facebook also has numerous privacy controls. It actually has a fairly robust set of privacy controls. For example, you can create custom groups of friends or connections, and you can differentiate who can see what you post. So to put this in context, I have a 2-year-old daughter. My wife and I have taken the position that although we want to share pictures of our daughter because we think she's adorable, we're trying to limit her social media exposure until she is at least old enough to make that decision for herself. So we each created on our Facebook pages a custom group of friends who are actively involved in our daughter's life that we feel comfortable sharing pictures with. We don't just share them for anybody to see. You can limit posts to being only visible by one other person. You can limit posts to only being visible to you so that they wouldn't be public at all. You can set your pages. By the way, this is distinct from profiles. Pages can be set to have different privacy levels as well. So a page can be a public page. It can be a private page, which means that people can see the content on it, but they can't actively post to it. Or it can be a secret group, which basically means that you won't ever see content on it. You can't search for it and find it. But if a member of the group invites you to join, then you can see what's on there once you're allowed in. Facebook also allows you to do both one-on-one messaging and group messaging, where you can engage in ongoing live chat or post messages that people can respond to at a later time. Twitter is a very, very different platform. It limits its users' posts, which it refers to as tweets, to 280 characters. That used to be, I believe, 140 characters, but they upped the limit relatively recently. However, those characters include both spaces and punctuation. You can retweet another user's tweet on your own account, and I apologize for the terminology here if it sounds silly. I did not make these terms up. Retweeting is essentially like forwarding an email. So you can forward other users' posts on your own account, just like those email chains, or if you get a funny joke from your friend, you can send it on to somebody else. You can delete your own messages that appear on your account, but if someone has retweeted the message, you can't delete the retweet. So, of course, this has led to, well, this and other things, have led to the notion that the internet is forever. If you put it out there on Twitter and someone else retweets it, then you basically have to assume that it will be out there forever, because there's really no way to effectively delete it from existence if someone else has forwarded it around. Twitter has only two privacy settings. It has public accounts and what it refers to as protected accounts. Public accounts are visible to literally anyone on the internet. If you have a browser, a web browser available, you can go to twitter.com and read the content of a public account, even if you don't have a Twitter account yourself. Protected accounts can only be seen by followers, each of whom has to be approved. So someone says, I would like to see your Twitter account, and you say, yes, that's fine, I'll let you see it. Once you are past that front door, though, you can see everything that the account posts. Unlike Facebook, there's no way to customize the privacy levels of different messages. Twitter also lets you do what's known as direct messaging, which is where you send a message to literally one other person. But that's different from what Facebook lets you do, where you can, as I said, customize a list of who can see each individual post and make that available to multiple groups of different people. There are some other social media sites out there, or sites that have social media-like content. Pinterest is one of them. I don't really understand Pinterest. I don't use it very much. The best explanation of it that I've ever heard was that it's kind of like having an online collection of bookmarks, or a bulletin board where you have pinned things that you think look kind of interesting and you want to go back and look at them later. Instagram is primarily used for sharing pictures and videos, but people can also make comments on them, and it has other networking capabilities. LinkedIn is primarily used for professional networking. I imagine many of us are familiar with LinkedIn. There is also Yelp and other professional reputation sites. They often have limited social media features where you can connect to other users and send messages to them. Usually these have some but not all of the features of Facebook and Twitter, and none of them is as popular as Facebook and Twitter are currently. So let's dive into the actual legal concerns here. We're going to start with confidentiality and HIPAA concerns. The first thing that you need to know is that literally everything that is posted on social media is by definition unencrypted, and therefore if you post PHI, it would fall within the definition of unsecured PHI, which means that any improper disclosure on a social media network will implicate both the HIPAA privacy rule and the breach notification rule potentially. Now, whether a breach occurs depends on the site and the tools that are used. You would have to know how the site operates to be able to effectively determine how widely disseminated information may have been if it has been improperly posted. But this is where the different privacy controls can be really meaningful in terms of analyzing what has actually happened when an improper disclosure has been made. Also, failure to address social media in your HIPAA policies may violate the HIPAA security rule, which requires you to create policies and procedures to address electronic PHI and how it's used in your practice. If you just have a blind spot for social media there, and you then have an improper disclosure on social media, that could land you in some serious trouble with the Office of Civil Rights for the Department of Health and Human Services, which is the entity that administers HIPAA and is responsible for HIPAA enforcement. The main thing to take away from this is that your policies and procedures should all be geared around avoiding improper disclosures on social media. I want to address one common misconception that I see pop up with a number of my clients. A patient inquiry to a practice made over social media is not an effective authorization for that practice to disclose PHI, which means if the patient says, hey doc, do you have the results of my test back yet? You can't say, yes, you're in the clear, or yes, but you should give me a call, or something along those lines. The mere fact that the patient inquired, even though that seems to imply that they want you to respond using the social media platform, it won't constitute a HIPAA authorization. HIPAA authorizations are specific documents. They're required by the HIPAA regulations to contain certain elements. It will look like a formal document that the patient will have to sign to allow for various types of uses or disclosures of PHI for which you need an authorization. And communicating over social media would be one of those things that you would need a specific authorization to do. So let's think about what are the ways in which improper PHI disclosures can occur on social media. It may sound crazy, but some of these disclosures can be intentional. One example is a physician from, I believe, the University of Chicago, or it might have been Northwestern, posted a photo of an intoxicated patient on their Twitter account when the patient came to the emergency room. I find this absolutely astounding. Obviously, the physician was terminated, but that is an example of an intentional posting. I think that it is far more likely that you will have inadvertent disclosures, but you could still have what I guess would sort of fall somewhere in between an intentional disclosure like the one I described and an inadvertent disclosure, such as if you have a group of clinicians who are members of a Facebook group and they have a chat window going between them where they're discussing something that happened at the office that day. All of those discussions, even though they are among covered entities, could be seen as an improper disclosure because they're happening on a social media platform, and Facebook is still retaining copies of all of this information. But other examples of improper but unintentional disclosures, suppose someone takes a selfie in the office, and in the background they capture the image of a patient. Well, that image is individually identifiable information, and therefore it is PHI. So the photograph of the patient in the background constitutes PHI, and if they then publish that on their Facebook page by talking about how great their hair looks that day or something, or how happy they are at work, that would constitute an improper disclosure. One example that actually happened to a client of ours, where we had to do a real breach analysis, was the client had a young front desk staff member who was relatively new to the group. This was a multi-specialty group, a fairly large set of clinics actually. and they had this young receptionist who was very enthusiastic about her job, really enjoyed working there. And because they treat a population that in some cases comes from rural areas, one of the patients came in and gave the front desk staff member an apple that they had grown in their own orchard. Well, that's all great, but, wonderful relationship with your patients. And this staff member posts on social media saying, we have the best patients. I love my new job. I just got an apple from one of our patients, and they brought it from their own orchard. Isn't that great? Well, that all sounds pretty innocuous, and there's really no PHI disclosed until you realize or you learn about the additional fact that in addition to posting the text, the front desk staff member had taken a photograph of the apple, which was sitting on top of a charge sheet for the day. Now, the good news was that the photograph was cropped so tightly and the shot was so close up and the apple was so large in the picture that you couldn't actually make out complete entries anywhere on the form. You could barely make out a couple of letters or numbers on either side of the apple. So fortunately, there was no actual disclosure of PHI. But if she had zoomed out with the picture, you would have seen, medical record numbers, patient names, dates of birth, something along those lines. That, I think, is far more likely to be the type of scenario where you're going to have HIPAA disclosures. It's rare that you're going to have people, although it can still happen, who are going to intentionally publicize PHI. But you're much more likely to have people who just don't think about what they're doing and don't realize that what they're posting constitutes PHI in that context. So let's move on to discussing malpractice concerns. The good news is that physicians are already pretty wary of using electronic media and social media specifically for clinical purposes. Interaction with patients over electronic media could conceivably improve the quality of care and enhance relationships between the physician and the patient, and you can rapidly disseminate information to patients. So, for example, if you wanted to circulate information about, an epidemic in the area, like a measles outbreak that had just happened in your town, social media could be a great way to get that information out there. But it probably is not a great way to actually practice medicine and really engage in clinical activity. So a Quantia MD survey that was conducted in August of 2011 found that over 40% of the physicians surveyed were not interested in diagnosing or treating online. That's a good thing. I think that's the right instinct. I have posted two of my favorite quotes here from that survey. There is no substitute clinically for actually seeing and examining the patient. And of course, my absolute favorite of all of the quotes simply reads, lawsuits, lawsuits, lawsuits. The real issue that you need to pay attention to in engaging in clinical activity, really in any online context, but in social media especially, is whether you have established a physician-patient relationship. If there is no physician-patient relationship, then there's no duty of care, and therefore you can't have malpractice somebody if you failed to live up to the duty of care, because you don't have that duty in the first place. They're not your patient. So for people who are not already patients, your goal is to not establish patient relationship. And of course that raises the question of, well, okay, how would you actually end up establishing a physician-patient relationship in an online context? The bad news is that because social media is so new of a phenomenon, at least within legal circles, we don't really have a lot of case law that has been established to analyze what kinds of conduct in a social media setting would establish a physician-patient relationship. But we can analogize from some other cases. And the real takeaway from all of this is that very minimal contacts with a prospective patient can create a physician-patient relationship. I'm going to give you a couple of examples here. One involved an attending physician at a teaching hospital who was found to have a duty to a patient who was being seen by a resident whom the attending was contractually obligated to supervise. Another example, my personal favorite just because of how convoluted the fact pattern is and how sort of off the wall it is, you had a fishing trawler that was located in the middle of the Bering Strait where the ship's medical officer, who was not actually a clinician, used a ship-to-shore telephone where they asked the advice of a contracted physician to diagnose a patient who had gone into diabetic shock, basically, and the patient eventually died, allegedly because the physician had not provided effective guidance over the phone. Now, in both of these cases, the pretty obvious answer is that, of course you would have had a physician-patient relationship because there were contractual relationships that already bound the physician in these cases to the patients, even though there was some separation between them and actually treating the patient. But there are a couple of quotes here that I want to read to you from some of these analogous cases, and I think they're really important if you consider them in the social media context. A physician-patient relationship, and thus a duty of care, may arise from whatever circumstances evince the physician's consent to act for the patient's medical benefit. Physician contact with a patient is not an absolute prerequisite for the physician-patient relationship. A doctor-patient relationship can be established by a telephone call when such a call affirmatively advises a prospective patient as to a course of treatment, and it is foreseeable that the patient would rely on the advice. It is not hard to imagine how these kinds of analyses could be expanded into the social media setting. Now, that's all about people who are not yet your patients and avoiding establishing a patient relationship. When you have an existing patient interacting with you over a social media setting, your analysis is a little more complex. So there's already going to be a duty of care established. The next question is going to be, did you meet the standard of care, and did your failure to adhere to the standard of care actually serve as the proximate cause of the patient's harm? I'm not really going to dive into that as much because that's more sort of garden variety malpractice law rather than something that's unique to social media. Social media, I do want to point out, also raises issues regarding confidentiality of records for purposes of discovery in a lawsuit. If you are engaged in communications with a patient over social media, all of that stuff is going to be public record. If you disclose something online, it can later be discovered and used in a lawsuit during the discovery phase because, as I mentioned, it's already pretty much public. You've destroyed any potential for asserting confidentiality, even if it is a doctor communicating with their patient. And just to sort of put this in context, we have one of my favorite lines here, which is that the E in email stands for evidence. The same could be said within social media, but I guess you have to look at the E in the middle of media, and it doesn't quite read as cleverly. But the bottom line is, if you disclose it online, it is very likely that that could be discovered in a malpractice lawsuit. So let's move on to some practical guidance. How can you approach the use of social media, given that it is a fact of life? You're going to bump up against this in running your practice. The thing that I really want to make clear is that it's really critical that you have developed clear, firm policies and procedures regarding social media, and especially with respect to HIPAA compliance. HIPAA in general imposes requirements both through the privacy rule and the security rule that you have written policies and procedures in place that you actively enforce to respond to the uses and disclosures of PHI, and particularly improper uses and disclosures of PHI. In broad strokes here, this is just ways that you can consider possibly limiting social media usage. Even outside of the HIPAA context, you can consider limiting the time that employees are allowed to use social media during work. Other things that you can do are install in your own computer system software that blocks certain websites, so people wouldn't be able to log on to Facebook or Twitter using their work computers. But the problem is that most people are carrying around a personal computer in their pocket in the form of their cell phone, and they can just as easily, take a bathroom break and hop on Twitter or Facebook or wherever else and post content on there. I think it is fairly impractical to try to completely ban the use of social media because of that, simply because of the ubiquity of cell phones and smartphones specifically. The other thing that you have to take into account is how your policies are drafted with respect to what kind of conduct you prohibit in the social media context. It's perfectly legitimate to say that you're not allowed to disclose PHI on social media. You're not going to have any problems creating or enforcing, you might have problems enforcing it, but no one will assert that it is improper for you to enforce a rule against disclosures of PHI on social media. But the National Labor Relations Board has published guidance with respect to what employers are permitted to do in terms of prohibiting employee conduct on social media settings. All of this revolves around the concept of what's known as concerted activity under the National Labor Relations Act. And what that basically means is concerted activity is where you have employees who gather for the purpose of engaging in mutual aid or protection. It's meant to essentially protect them so that they can coordinate their activities if they want to protest their employer's business practices, for example. If you want to form a union, you're allowed to get together and form a union. This has been extended into the social media context to mean that employers are not allowed to have policies and procedures that say things like you're not allowed to ever speak ill of your employer online, because that could implicate essentially the equivalent of digital picketing, such that an employee could complain about their wages online and say something like, my employer isn't paying me a living wage. I encourage people to boycott this employer until they, give us a raise or something like that. That type of policy is generally not going to be enforceable under the National Labor Relations Act. But that doesn't mean that you shouldn't have policies and procedures in place to address things like HIPAA and the disclosure of PHI. I think it's also a good idea to limit who is actually allowed to post on the practice's behalf in the social media context. You may want to have a designated social media officer. This can be someone who manages your social media accounts. That could even be a primary job for them. They have no other duties depending on the size of your organization. If you're a small practice, that's probably not, going to be someone's full-time job, but you can still limit the number of people who are allowed to use the practice's social media account in posting. I'll also point out that I think it's reasonable to say that people are not allowed to represent their workplace online unless they have been given explicit authority to do so. And you could have a social media policy that states that, the theory being that you don't want just some random employee going out and acting as if they speak on behalf of the entire organization when they clearly don't. Some other things to consider in terms of practical guidance: you're going to have some potential generational differences. I'm 40 years old. My parents' generation looks at social media, generally speaking, as completely insane. Why would you want to broadcast anything about your life? Privacy is much more of a concern for them. My generation, which I'm not entirely clear is either Gen X or Gen Y or the beginning of the millennials, I tend to think of myself as a very, very late Gen Xer, but I don't suppose it really matters. My generation and Gen Xers in broad strokes are comfortable using it, but we're still, cognizant of privacy considerations. Just by way of example, my own decision not to post my daughter's photos everywhere. I have friends who still do that, though. They post it for everyone to see, as far as I know. But the generations that are younger, millennials and whatever the name of the generation is that's younger than them, they have grown up with social media. This is a world that they have always had around them. They don't remember a time before the internet, really. It might have been like the first few years of their life, but if they've had a computer when they were growing up, chances are it had the internet, and for a good portion of that time period, social media has existed. So they're very comfortable with broadcasting their lives, and broadcasting all manner of aspects of their lives. I think the real goal with all of this is to teach employees to stop and think twice before they post something. Just whatever your training is, the goal of it should be to get an employee, before they click send or post or whatever the button is that you hit to get a message up there on social media, you want them to stop and say, hang on, is this okay for me to post? Maybe I shouldn't do this. If you're able to do that, then you're in much better shape. If your employees are just posting things willy-nilly without it ever popping into their head, then you're a lot more likely to have those kinds of inadvertent disclosures, like the apple on top of the charge sheet, or the selfie that catches the patient in the background, or worse, the obnoxious physician who wants to shame a patient or talk about how ridiculous a drunk patient in the ER looks, and who posts it intentionally. One thing that you may bump up against is that physicians who set professional boundaries, for example, who say, I will not friend a patient, I will not connect to you on social media using my personal account, that could potentially lead to patients feeling shut out of their physicians' lives. On the other hand, patients may not want to let physicians into their lives that way. Just the simple question of how many drinks do you have in a night, well, depending on what someone's posting on social media, the answer they tell the physician in the office might appear quite different from what you might gather from looking at the string of photos from last weekend's pub crawl. So patients may be a little more cautious about this than initially you might think, but it's still a potential risk and something that you'll need to take into account. I still think it's a good idea to maintain professional boundaries, though. Professional associations out there have generally agreed with this point of view. Now, I posted here that the AMA has suggested maintaining separate accounts on social media, having both a professional account and a personal account. I believe they have revised that guidance just because of how impractical it might seem to maintain a separate professional account and a personal account. I don't think it's that impractical, depending on how active you're going to be on either of those. If all you ever do on your professional account is engage in sort of professional self-promotion or, awareness activities or something along those lines, I don't really see a problem with maintaining a separate account. But it's not really something that they say you definitely ought to do anymore. I still think it can be useful in certain circumstances, though. The American Association of Family Practitioners suggests not accepting patient friend requests and instead redirecting patients to connect with a physician practice's business. The American Colleges of Physicians have advised using the same standards online that you would use in a clinic or in interpersonal circumstances outside of the online context. If you wouldn't go out and have a drink with a patient, maybe you shouldn't be friending them on social media either. They also say that you can be aware of privacy settings on social media sites, which can mitigate some of the difficulties in maintaining boundaries between the personal and the professional. So let's talk a little bit about HIPAA specifically. As I mentioned, it's really important to understand how information flows on social media networks, particularly how quickly it can be disseminated. I think it can be useful to demonstrate this when you're training your employees specifically in the use of social media and HIPAA within that context. A tweet could go viral very, very quickly, and it can spread much faster than you will have the ability to rein it in. Facebook postings may be a little easier to control, again, depending on the privacy settings that are enabled on the account. But even so, I still think it's really important to understand how these networks work so that you can effectively craft policies and procedures to address them. I advise educating practice employees at all levels of the practice, from physicians, and by that I mean even partners, shareholders, owners of the company, all the way down to anybody who really works in the office, about what constitutes PHI in context. As I mentioned, a selfie might not normally occur to somebody as being a disclosure of PHI. What are you talking about? It's just a picture of me, right? Well, you could demonstrate PHI by saying, for purposes of this illustration, consider that Dr. Smith is a patient of the practice. Imagine that Dr. Smith is a patient of the practice, and Dr. Jones has just taken a picture of themselves. See if you can find Dr. Smith in that picture. And if the employees can find them, then that's an example of PHI being posted in a social media context. Other things might be computer screens that are visible in a picture, or disclosing sufficient details about a patient where the poster thinks that the post is anonymous because it doesn't include the patient's name, but because you know what time of day it was posted, and you know the type of injury that occurred, and it's tied to an event that's widely known in the city, or something like that, someone might be able to figure out who this person is just by sort of reading between the lines of a post. And you have to remember that PHI is anything that can individually identify a patient. So remember that you need to really understand PHI in context. I also really strongly advise using more secure methods of communication, or even suggesting telephone or in-person meetings when a patient inquires online. So, for example, a patient goes to your social media page for your practice, and they say, I've been trying to contact my doctor, but I haven't heard anything back yet. I'm worried that the following sensations that I'm feeling might be a problem. What should I do? The response from the social media officer should be, we never publish information. We don't respond to clinical requests online to ensure our patients' privacy. If you're having an emergency, contact the emergency room. If it's something that you don't think is an emergency, please use, if you have a patient portal, advise them to use the patient portal, or call the office on the telephone, and we'll do our best to assist you as quickly as possible. I really strongly advise using patient portals for these types of things, typically because patient portals are secure for HIPAA purposes, which means you don't have to worry about the breach notification rule. Again, because portals are encrypted, they're secured, it's a much more protected way of communicating with patients. Lastly, I would say update your security risk assessment. I'm going to assume here that everyone has conducted a security risk assessment. If you haven't, get on that, because we are seeing more enforcement in the realm of HIPAA where people who have failed to conduct a security risk assessment get penalized for that, and pretty steeply at that. You can go on the OCR's website, that's the Office of Civil Rights, and read stories about settlements that they've reached with physician practices who have failed to update their security risk assessments, or who have had some kind of breach. And typically when you're reading about that breach, they'll say they also had failed to update their security risk assessment. So update that document. And if you haven't done one in a very long time, undergo a security risk assessment. With respect to malpractice and avoiding malpractice, the simplest approach to avoiding malpractice altogether in the social media context is don't engage in clinical activity over electronic media, and specifically over social media. Policies that you have in place should deal with how to respond to various types of patient inquiries. So, if a patient posts a picture to the practice's Twitter account that says, hey, does this look infected to you? Again, the practice's response should be, we never respond to clinical inquiries online. We recommend that if you are a patient, you contact the practice directly through the patient portal or to pick up the phone and make an appointment. For more serious inquiries, such as, am I having a heart attack, recommend contacting the practice, or better yet, go to the emergency room. Don't respond with a specific diagnosis. You would think I wouldn't have to mention that. Sadly, you would be wrong. I have found a Twitter account where a physician was asked whether certain symptoms were signs of a heart attack or indigestion, and the physician replied, and I quote, if movement, deep breath, swallowing makes pain worse or better, it is, in all caps, not a heart attack. That's right there on Twitter, and also conveniently discoverable in any eventual malpractice case. So yeah, don't go posting that kind of information online, particularly in an emergency context. The doctor's company has stated that social media is not appropriate for doctor-patient communications, and they also note that it is all available for discovery when a plaintiff's attorney is looking around for information to help them make the case. And again, for individuals who are not patients, the goal is to avoid establishing a doctor-patient relationship, and the easiest way to do that is, again, to not provide clinical information or respond to clinical questions. With existing patients, the goal is to avoid harm. So if you want to provide a patient with information, there's really nothing wrong with, providing them with general information. So if the patient says, I'm worried about XYZ symptoms, you can direct them to a JAMA article or a WebMD entry or the CDC webpage on the subject without actually making a diagnosis. That's not you making a diagnosis. That's saying something to the effect of, here are the symptoms of what this is. I'm not telling you whether it is that or it isn't that. This is just, take a look at an encyclopedia. If it's anything more serious than that, take it offline. At best, really I think the best thing would be to set up an appointment in person with the patient or to have a telephone conversation with them. If that's not going to be possible, using the patient portal if you have one, but don't engage in a long online back and forth about what will constitute, what their symptoms are, is it anything to be worried about, that sort of thing. Again, because it just creates a paper trail. And it's all unsecured when it's happening over social media. So to wrap things up, as I mentioned earlier, electronic communication is just a fact of life now. There's no getting away from it. We all have, the equivalent of 35 millimeter cameras plus personal computers in our pockets most of the time. People post on social media all the time, and they're very comfortable doing so. Communication is going to happen over these mediums. Social media can really be a very useful tool as well for medical practices and can be a great way to promote your business. You can raise your business's profile. You can communicate with patients really useful general information like, hey, it's fall season, so remember, it's flu season, so remember, wash your hands thoroughly, and you can link to a video that has one of your clinicians saying, sing the ABC songs while you're washing your hands, and that's how you know that it's been long enough to kill any germs. Or, better yet, do the middle part of Bohemian Rhapsody or something like that, which I think I actually did hear on NPR once. That advice, not Bohemian Rhapsody. But it's important to remember that as younger patients enter the market, this is going to become even more of a factor. The more people who have grown up with social media entering the medical marketplace, both as patients and as clinicians, the more you're going to have to address this in how your practice operates. And just to put this into context, my wife is 34 years old. She is, technically speaking, a millennial, and she is a family medicine physician. So she's someone who grew up with the internet, went through most of high school and college with social media in pretty much the form that it is now, and she is a practicing physician. Now, the good news for us is that she's generally very conscientious about her conduct online, but not everybody is necessarily going to be. So you need to really be taking that into account when drafting your social media policies, which you should, again, be drafting. And I think it's really important to understand what the legal risks are in this setting and how to navigate them. And if I may say so myself, I think having legal counsel to help you navigate these processes can be quite useful and even essential, because lawyers are going to spot stuff that you might not necessarily consider. One final slide here. I've included 2 articles that I have written on social media. One is available on our website. This is posted in a book, so it's actually a chapter from a book that we put out each year called the Health Law Handbook. It's a much more in-depth discussion of social media that includes a whole range of information, but I like to think that it's not written in impenetrable legalese. The other is an article that I published in the PA Pulse, which is the Pennsylvania MGMA's newsletter, in their September/October 2017 article. You can likely get a copy of that from the Pennsylvania MGMA. I believe a copy of that's also available on our website as well. And with that, I'm going to open it up for questions.
Thank you. As a reminder, everyone, you can enter in your questions on the chat box on the left-hand side of your screen. We do have a question that came in. Can we acknowledge the patient relationship on Facebook if the patient comment or acknowledged us as their provider first?
I would generally advise not doing that, if only because I think it is too close to you releasing PHI, and I realize how goofy that sounds. Unfortunately, this is the nature of HIPAA. HIPAA was created before social media, well, really before social media was even conceived of, given that the law was passed in 1996 and the internet was really just getting started at that point in any meaningful fashion. So I would not acknowledge a patient relationship unless you already have a patient's written authorization to do so. And by that I mean a HIPAA authorization that the patient has signed that says, I give you permission to disclose PHI to me using, XYZ social media platform. You might have patients who really prefer to do that. They may just really love Twitter or Facebook or something like that, so they want you to send them information there. But I generally wouldn't do it, if it's just someone saying, here are my lab results back in, yes, but please call the office. I wouldn't engage in that. I think a sort of a stock response, as annoying as it may be for your patients, is the better way to go. And then when they call you up on the phone and they say something like, hey, how come you wouldn't answer this? That was so goofy. You can say, yeah, look, I know, but those are the laws. We got to comply with the laws. We'd get in trouble otherwise.
Thank you. A second question came in. Is communication through cell phone text the same as communication through social media in the terms of HIPAA and malpractice?
It's funny that you mention that, because there's actually a whole other speech that I give on the use of mobile devices and bring your own device policies. This is something that's become a lot more popular in recent years, particularly where physician practices and other provider settings are trying to save on expenses. They may permit people to use their own cell phones. Generally speaking, I would not use text to communicate with patients unless it is a secure texting program. And they do make those, by the way, but just the sort of basic, Google Text or Apple Text that's on your iPhone or your Android phone, that's not going to be secure for HIPAA purposes. And Google and Apple are already retaining copies of those messages anyway, and they likely will not have signed a business associate agreement with you to do that. So I would not use regular text to communicate with patients, again, unless they have signed an authorization to do so. Now, what you can do is if you have a secure texting mechanism, you can have patients, communicate using that. Better still, if it connects with your patient portal. You might be able to get a portal that has sort of a texting function built into it, and then I would say that it's probably not a problem to use that. But just to use the basic texting function on your phone that comes preloaded, I wouldn't do it.
Next question. Can you give an example of how to respond to patients making misleading or false statements on social media about the doctor or practice?
Okay, so this question gets in another issue that has popped up a lot in recent years, which is the issue of reputation management. As websites like Yelp have become more popular and all the various other review websites, there is a real risk of patients posting negative reviews. And unfortunately, negative reviews often tend to speak fairly loudly when people are considering who their healthcare provider ought to be. I would advise not responding to a patient's negative review substantively, and by that I mean in a way in which you, A, acknowledge that the patient is in fact your patient, and B, that would reveal any details about the nature of the treatment that you've provided. So if a patient says, I came to you to have XYZ procedure performed and you botched it, I would not advise responding, that's completely ridiculous. We performed that procedure to the widely established standard of care, and here's a New England Journal article that proves it, and we did everything that's in that article. I wouldn't do that because that will be acknowledging the physician-patient relationship, which again could constitute disclosure of PHI. And again, it also provides evidence in any eventual malpractice case. That doesn't mean that you can't reply at all, though. And I think there are things that you can post that will be meaningful replies and will help protect your relationship. Definitely don't respond in anger to the patient because that's just not a good look on anybody when you're in a service industry. And, healthcare is essentially a service industry in that sense. I think it is reasonable to post something like, we take our patients' concerns very seriously, and we would hope to resolve any disputes if you or any other patient, or not you, rather if a patient has had a negative experience, we would ask them to please contact us directly over the phone so that we can work to resolve whatever their complaint may be. That's not acknowledging that the person is a patient, but it's giving the appearance that you really do care about what your patients think, and you want them to have good experiences. The other thing that you can do with your patients is, for existing patients who have had positive experiences, you can ask them to post their positive reviews online. Don't give them anything for doing so. Don't incentivize them, posting online. Don't give them a gift card or discounted services or anything like that, because then you could run afoul of beneficiary inducement prohibitions in the federal anti-kickback statute and fun stuff like that. But there's nothing wrong with saying, hey, listen, if you've had a good experience, we'd really appreciate it if you could post about it online. You can direct them to whatever website you want them to go to do that. Positive reviews can often outweigh negative ones. One of the other things that I'll point out is that negative reviews, not all negative reviews are created equal. I mean, if you have a negative review that's mostly gobbledygook, it's written in all caps, or it contains a ton of misspellings, or it doesn't really read very clearly, people may be more inclined to disregard that than someone who posts a coherent real takedown of a practice, saying I had to wait for an hour and a half in the waiting room for my 9 a.m. appointment on a Monday, which is completely ridiculous and blah, blah, blah. If they write down something that's actually well written, that's probably going to carry more weight than someone who, just sort of blathers and rants. I will also point out two other things. Probably not a good idea because you're unlikely to win. You can't really sue the review sites because most to take down true reviews, but you can also use review sites features where you can challenge certain reviews if the review is bogus. So, for example, if someone says, I came to you for a facelift and it was terrible, and you say, what are you talking about? We're a cardiology practice. You can get that review removed. That's going to be pretty easy to do. You don't even provide those services. And I've seen that happen before. But if it's something where, you go to the cardiologist's practice website and it says the front desk staff was rude, you probably have a front desk. So saying we don't even have a front desk isn't really going to work. There are also problems with trying to sue patients directly. Some states prohibit what are known as strategic lawsuits against public participation. They have laws that will penalize someone who files basically a suit that's just designed to shut a patient down, by making it too expensive for them to post their grievances. But that's quite a rabbit hole to go down. I'll be happy to explain that in greater detail, although I do talk about it in the Health Law Handbook article. So you can take a look at that if you're curious about more.
Thank you. Are there any additional questions? No? Okay, so thank you for attending today's webinar. The recording will be distributed to all registrants through email. If you attended today's webinar as a non-member, please inquire about membership opportunities through your local MGMA chapter. At the conclusion of this webinar, you will be sent a brief survey that will ask you to rate the webinar on a 5-star scale. A separate survey will be sent to your email for a more in-depth look at today's program. That concludes our webinar. Thank you again for attending, and